We want to discuss further a major story of the week, which is that the U.S. Supreme Court now ruling on former President Trump's immunity case after hearing arguments from both sides on Thursday. Now, Trump was charged with 4 criminal counts in connection with what special counsel Jack Smith claims was a scheme to subvert the transfer of presidential power after the 2020 election. Trump is the first former president to face criminal charges. So while Justice Department policy prohibits the indictment of a sitting president, there is no bar against charging a former one. Special counsel Jack Smith's team says the founding fathers never intended for presidents to be above the law, and that in any event, the acts Trump is charged with were not part of a president's official duties. However, Trump's attorneys say former presidents are entitled to absolute immunity. They warn of a potential floodgate of prosecutions against former presidents if they are not entitled to immunity, and say the office cannot function if the commander-in-chief has to be worried about criminal charges. I do want to bring in Seth Berenzweig, who is a business and compliance attorney who has talked to us about this issue before. And Seth, thank you so much for taking the time to chat with us.
Thanks for having me back.
So when it came to hearing the argument on Thursday from both sides, Trump's attorney and the special counsel, it was incredible to hear the nuances of this argument and the potential implications, whether what ruling comes out of it. What was your takeaway from the arguments on Thursday?
Well, my first takeaway was that this was certainly historic. It's the first time that the Supreme Court has been asked to rule on this issue, whether a former president who allegedly engaged in criminal acts during his or her term can be held criminally responsible after the completion of that term, or whether the president is entitled to use Mr. Trump's terms, absolute executive immunity. I doubt that he's going to get specifically what he asked for. But the thing that I found really interesting during the hearing was that you gradually were hearing the justices getting divided into 2 camps. There was the more liberal camp that really fell on the side of how could you possibly expect this to lead to anything other than a criminal factory of anarchy, because they were going through a lot of examples to show just an absolute deterioration and lack of deterrence if that was a rule that was adopted by the Supreme Court. On the other side of the fence, you saw the conservative justices that were actually asking the question of, shouldn't we think more carefully about this? In other words, asking whether or not there should be a better articulated standard to determine whether or not something flows in or out of the scope of executive authority. So those are the 2 camps that were really kind of gelling together as the hearing proceeded, and it was certainly a moment in judicial history.
Absolutely historic indeed. And it seemed like there was one central question that justices began to focus on, which is what constitutes an official act. And again, there really is no official definition. What does constitute an official act? And if there is no accepted definition, how does one create that legally?
Well, I think you've really hit the nail on the head. That's exactly what the dilemma is before us. And my problem with that issue is that it's like trying to re-engineer common sense. What usually happens in the course of a trial is that the jury resolves disputed fact issues, which includes factual disputes that would ultimately resolve as a measure of common sense. And there could be a jury instruction to the jury to determine that if you find that this was within or without the scope of the president's job, then you would proceed accordingly. The thing that I find very surprising and momentous about this aspect of the Supreme Court's hearing is that I think this is a solution looking for a problem. I really don't think this is something that needs to be delved into by the court. I think it's pretty clear that the Supreme Court will not wholesale grant what Mr. Trump wants, but I think that we may see a compromise middle ground where the court both rejects the absolute request for blanket immunity, but tries to find some kind of a system in the middle. Although, quite frankly, I think, again, I think it's a solution looking for a problem, because it's okay for a jury to be able to balance matters of common sense. It was just one of the surprising aspects of why the Supreme Court, in my view, accepted this appellate review to begin with.
Yeah, so given that, and again, there is no necessarily specific timeline for when justices have to make their ruling. Of course, it has to be before the end of their session in June.
Right.
However, when we're taking a look at this, and from the arguments and the line of questioning that we heard on Thursday, looking into a crystal ball, of course, we don't necessarily know exactly what will happen, but does it look likely that they'll hand this back down to a lower court, or do you think that they'll actually make a ruling?
Well, I think what they will probably, in sum and substance, end up doing is they will probably release this on one of the last, if not the last day, at the end of June. And what they will most likely do is they will remand the case down back to Judge Chutkan in the D.C. District Court, the federal court, for further proceedings consistent with a likely delineation of what the legal standard is that the jury needs to apply as to whether or not it falls within the scope of executive authority, whether or not it was a political act, a personal act, or whether it was an executive act that fell within scope. So there will be a ruling that will come down right before the 4th of July weekend. It will probably remand the case back down to the district court. Judge Chutkan has said that when it gets back, that she estimates the trial date to be approximately 90 days after that. So we're probably looking at a trial that would start on or about October 1st.
And when we're talking about a trial, are we talking about a jury trial, or are we talking about a trial before a judge?
Well, that's a great question, because if you took a look at some of the recent litigation history in New York, the corporate fraud trial, for example, in front of Judge Engoron was not in front of a jury, and there's debates about why that was. But this will be in front of a jury. This will be a jury of Mr. Trump's peers. If that's something that could apply in this particular instance. And it will be a jury trial, which means that the applicable standard of this precise part of the case will probably end up being adopted into a jury trial. Now, one of the aspects of the predictions out there is that they may remand back to the appellate court for some kind of intermediate appellate review. I don't think that's likely. Some are suggesting that there may be some kind of a preliminary hearing. I don't think that's necessary or likely, because you can just try the case. There can be a burden placed upon the prosecution to delineate whether or not this fell outside the scope of his authority. And the prosecutors will simply say this, and this is just an allegation. Mr. Trump has not yet been found guilty of this, to put it at the least. But they will say, how can calling a crowd to burst into the United States Congress and try to execute the vice president fall within the scope of his executive authority? How in the world could that happen? So again, that's just an argument, and Mr. Trump's going to be afforded full due process under the law, but I believe it will probably follow along that path.
And again, I think because it does seem likely that the Supreme Court will remand this case back to the lower courts, what do you think was their reasoning for accepting it in the first place?
Well, that's really one of the big questions of the month, because that's really hard to say. It begs the question of whether there was a little bit of a political flavor that was thrown into the stew as far as the manner of review. I think that probably applying a good faith assumption to this was the Supreme Court saying, look, this is a moment in American history. It is going to be important for the ages, for us as the Supreme Court justices, to lay down the standard so that there can be no misunderstanding, and that people can understand with a reasonable degree of certainty what the underlying legal standard is as to what falls within the scope of executive authority. So I'd like to think that that's probably what they did. It was a case of significant magnitude, and we will have a decision on the table within the next couple of weeks.
And no doubt there's going to be a lot of conversation once that decision is handed down. Seth, is there anything else that really stood out to you, again, during the arguments on Thursday, but also looking ahead to that decision that we're anticipating happening before July 4th?
I found it really interesting that during the course of the hearing, when Mr. Trump's attorney was pressed very aggressively by some of the more liberal justices, and in fact, even some of the conservative justices, to go through the elements of the indictment and ask whether some of those components, and as alleged, were personal acts that he did concede in several instances that he conceded those were personal or political acts for his own personal advantage and not executive actions. I thought that was very interesting. Overall, I thought both counsel did a very good job in front of the Supreme Court, but I suspect that that will be an aspect that will flow into the language coming out of the Supreme Court's decision that we'll be seeing very shortly.
Absolutely fascinating. And as you mentioned, Seth, historic in nature. So again, as you mentioned, the justice is not taking this lightly at all. Seth Berenzweig, an attorney, thank you so much again for taking the time to speak with us here on Live Now from Fox. We always enjoy your thoughtfulness and your expertise.